case began back in 2014 when two men from upstate New York were denied concealed carry permits. Meanwhile, the Supreme Court decision in New York State Rifle and Pistol Association versus Bruin marks the widest expansion of gun rights since 2010. In-depth analysis from Andrew Lieb, constitutional attorney in New York with Lieb at Law. Andrew, first off, your reaction to the ruling.
I wasn't surprised whatsoever, and the reason is because in 2010, the Supreme Court issued a very similar decision, and that was with less conservative justices. Now they have even more, and what they did is expanded the prior decision of a right to have a gun for a private citizen in their house to say you can have it anywhere now.
Yeah, okay, so explain that a little bit, because as one story I read said, the decision swept further than the rules for concealed weapons permits.
Much further, much further. What the rules say now is that there's a shall issue rule when someone wants to have a handgun. Previously in New York, we had a law called the Sullivan Act from 1911 that said you could only have a gun if you had a particularized risk of safety. They flipped that on its head. They said now you can have a gun as the default rule unless you're in one of these places, only these places called sensitive places. And the court used examples like legislative assemblies or polling places or courthouses. And they said unless a state can show through historical context and through analogy to places like one of those three places, there are no constitutional restrictions on guns.
What about at schools?
It's a great question. That left open. And Justice Thomas wrote this opinion on his birthday. I don't know if you know, it's Justice Thomas's birthday. And when he wrote this opinion, he said, listen, I'm not going to address specific places. What I'm going to do is tell you three places from history that were allowed, and states and courts are going to have to look through analogy to see if that's a place like one of these three places. I'd bet a place like schools they could restrict guns from. That being said, it gets much more attenuated when you start talking about the subway system or restaurants or bars. Who knows?
We're speaking with Andrew Lieb, constitutional lawyer. He's at Lieb at Law in New York, and we're talking about the Supreme Court ruling in favor of gun owners in New York. So what about similar laws in other states now? What happens?
I'm glad you brought that up, because when the Supreme Court rules, they don't just speak about New York, they speak about the country. And this was a Second Amendment decision, and what this decision did is it said there's 43 states that have what's called shall issue laws. But there's 7 states, including New York, that's 6 more, that don't have it. And what this law said is all those states that don't have shall issue laws, when you want a gun, you get a gun, they're all going to be overturned. This is a precedent for everywhere. And another important aspect of this decision, where it goes further than the 2010 decision, is we used to think not only could we look to history to restrict guns, but we could say a state has a right to promote a public interest like safety. The Supreme Court said, oh no. The Supreme Court said only history on these sensitive places is the basis for any state, New York or the other 6, to restrict guns into the future.
Wow. So the mayor of New York City, Eric Adams, a former cop, says that policing will be more difficult. At least that was his comments kind of anticipating that this would be the ruling. Is he right?
Well, I'm not a police expert by any stretch of the imagination, but I've definitely been to a heated fight in New York City before. And knowing now that the guy you're fighting with may have a gun will probably create more violence moving forward. I like to say it like this, that everyone seems like they're under control and great until they get into a friction moment. And we don't consider what happens in a friction moment. So I will say it's going to be harder, it's going to be more problematic, but who cares, says the Supreme Court, because the Second Amendment, which has been around since 1791, that's the law of the land, and we can't worry about if it's going to be harder policing. What we have to worry about is government infringing on individual rights.
Yeah. How will this affect the gun legislation just passed by the Senate?
Who knows? Like, this is going to be a very interesting thing. I don't know if you saw certain senators, like Senator Paul, already commented that this could be problematic with respect to red flag laws, because he said things like you don't have due process before they take the gun. And these are going to be questions that are left unanswered. And Justice Thomas was very clear in his opinion that he's not going through the entire landscape. He's just setting forth a new rule. And the new rule moving forward which I think that we have to look at when we're dealing with any of these things, is to justify a firearm regulation. A government must demonstrate the regulations consistent with the nation's history, tradition of firearm regulation. So we have to look back to that year, 1791, and we have to analogize and say, could you do it? I don't know, but that's why I'm not on the Supreme Court like Justice Thomas.
Thanks, Andrew. Andrew Lieb, constitutional attorney in New York with Lieb at Law.